Hi all, welcome. We are going to get started. I want to again welcome folks to today's webinar hosted by Cornell's ILR School Center for Applied Research on Work, CARO, and the Labor and Employment Law Program. My name is Megan Thorsfeldt. I'm the Associate Director of CARO, and I am here to welcome our audience and wonderful panelists to today's webinar entitled Worker Protections at Risk, the Supreme Court Abandoned Chevron Deference. CARO exists to transform labor and employment research into practice. We seek to study work and to make that research accessible to practitioners and policymakers to improve the world for workers, their families, employers, and communities. And in that effort, CARO is thrilled to be hosting this discussion with the Labor and Employment Law Program, which will shed light on one of the recent dramatic decisions by the Supreme Court, which overturned years of precedent and alters the regulatory framework by which federal administrative agencies operate. As policymakers and practitioners seek to understand the scope and impact of these changes on labor and employment law, I am delighted that this discussion will provide helpful insight and framing to guide this important discussion. For folks who just joined, I want to let folks know that we have a transcriber with us today, providing real-time captions throughout this webinar. You can access them by going to the CC button in your Zoom menu and turning captions on. And you can also open a separate browser window, which allows for visual customization. With that, I want to turn it over to my colleague, Esther Bigler, the Director of the Labor and Employment Law Program, to kick us off and introduce our panelists.
Thank you, Megan. As many of you know, the Labor and Employment Law Program has for years been offering webinars, forums, and conferences exploring labor and employment law issues and decisions with the goal of impacting legislation, policy, and litigation, and today is no different. In this webinar, we dig into the meaning of the Supreme Court's decision in Loper Bright Enterprises, overturning Chevron Deference. Our experts today will analyze the decision and its meaning as we know it today. As the courts and the agencies operationalize this decision, we will clearly learn more. A few administrative details. Please put your questions in the Q&A section. The chat function has been disabled. We have left the last 20 minutes of the program to answer the questions you've put in the Q&A. Given the breadth of this decision and the enforcement of federal law by the National Labor Relations Board, the EEOC, and the Department of Labor, we will do our best to answer as many of your questions as time allows. Let me introduce our panel of experts in alphabetical order with a short summary of who they are. Craig Becker is the senior counsel to the AFL-CIO, that's the American Federation of Labor, Congress of Industrial Organizations. He co-authored the amicus brief to the Supreme Court in the Loper Bright case on behalf of the AFL. He was the general counsel of the AFL from 2012 to 2022. Before assuming that position, he was a member of the National Labor Relations Board, having been appointed by President Obama in 2010 and serving until 2012. He also clerked for the United States Court of Appeals for the Eighth Circuit, and he teaches labor law. He has published numerous articles on labor and employment law in scholarly journals, as well as in the popular press, and has argued labor and employment law cases in virtually every court of appeals and before the United States Supreme Court. Fred Jacob is the solicitor of the National Labor Relations Board. As solicitor, he serves as the board's chief legal advisor on questions of law regarding the board's operations and the adjudication of NLRB cases in federal courts. From 1997 to 2014, he worked in offices throughout the NLRB, primarily as an attorney, supervisor, and deputy assistant GC in the appellate and Supreme Court litigation branches. Prior to his appointment as the NLRB solicitor, Mr. Jacob spent 4 years as solicitor of the Federal Labor Relations Authority, where he represented the authority before all federal courts and served as in-house counsel. Mr. Jacob also clerked for the United States Court of Appeals for the Fourth Circuit. He teaches labor law and has published articles on labor and administrative law in scholarly journals. He is a fellow of the College of Labor and Employment Lawyers. Charlene Obenauer is the executive director of the New York Committee for Occupational Safety and Health, NYCOSH. In her role as director, She oversees and develops NICOSH's campaigns and advocacy work, bringing a vision to NICOSH that incorporates research, education, training, coalition building, and member development in order to create a healthier set of jobs in New York State. She is the co-founder of New York Health Nail Salon Coalition, which successfully advocated with then New York State Governor Andrew Cuomo for the passage of statewide legislation to combat wage theft and mitigate safety and health hazards in nail salons. She has been an advocate for safe construction and served on then the Manhattan Borough President Gail Brewer's Construction Safety Task Force and has worked with the Manhattan DA. She is also a founder of the Temp Coalition, advocating for extreme temperature standards for New Yorkers. She sits on the advisory council of the Downstate Occupational Health Clinics and is chair of the New York Immigrant Community Empowerment. Charlene has been featured in numerous publications and on TV. And now for my first question. Fred, can you please, we lost Fred. Have we lost Fred's on the Zoom? Okay, I'm going to go to the next question and hopefully Fred will find his way back onto our Zoom. Craig, can you please talk about the Loper decision? And there's been a lot of hand wringing about this decision and what it means. So could you talk to us a little bit about what are the limits of this decision and where are the loopholes? And as you do that, if you could give us a little summary of exactly what the decision stands for, I'd appreciate that.
Sure. Why don't I answer the question that you were going to ask Fred briefly, and then hopefully he'll reappear and can answer it at more length. So Loper Bright and its companion case reversed a case called Chevron versus Natural Resources Defense Council from the 80s. And that case established essentially a principle of deference when Congress drafts a statute, enacts a statute, and authorizes an executive branch agency, the National Labor Relations Board, the Environmental Protection Agency, Occupational Safety and Health Administration, to enforce and administer that statute. When a provision of the statute is ambiguous, you can't tell for sure what Congress intended. It's up to the agency to construe the statute. And the courts, so long as Congress has not spoken clearly, and so long as the construction is reasonable, should defer to the agencies. The theory being when Congress has not spoken clearly, it's better for the political branches to make those decisions than the courts, unelected judges. So that principle of deference existed since the 80s, and in fact, long before the 80s. In many cases dating from the 30s and 40s, important cases construing the National Labor Relations Act, for example, the court articulated principles of deference which were very similar in terms to what then was systematized in Chevron. So that's been the law for decades. In Loper Bright, the court reversed Chevron, holding that under the Administrative Procedures Act, here's Fred, under the Administrative Procedures Act, a statutory holding, not a constitutional holding, importantly, Congress instructed the courts to say what the law is. How about if I stop and let Fred jump in?
I am so sorry. Of course, it's while you're on a webinar that the internet completely cuts out in your remote New Hampshire house that you're in.
Oh, it looks like Fred froze.
I'll keep
So
talking.
I think
can
Craig, you should
jump back in.
continue to speak until he's able to come back.
So the court reversed Chevron in a 6-3 decision along strict party lines and said that under the APA, it's up to the courts to determine what the law is. The single best answer, even if it appears to be ambiguous or uncertain, it's up to the courts to come up with the best answer of what Congress meant. So that's what the decision holds. And let me go on to the question posed to me. That is, what are the limits, important limits to this decision? And I want to address four such limits. The first, and I think very important thing to recognize, is this is a double-edged sword, depending on which side of the street you sit on. So we at the AFL have argued against deference in the Trump administration, in the second Bush administration, in the first Bush administration, et cetera, et cetera. So sometimes we're in favor of deference in the present moment, for example, but sometimes we're against deference. Chevron itself, importantly, as I said, was a case brought by the National Resources Defense Council against the EPA, headed at that time by Justice Gorsuch's mother. And the argument was that the rule at issue was too weak in protecting the environment. So, as I say, importantly, this is a double-edged sword. Sometimes less deference will be beneficial to the labor movement, for example, and sometimes it will be deleterious. Importantly, also, this lower level of deference will apply to deregulation as well as regulation. So if we have an administration which wishes to deregulate in certain areas, environmental regulations, labor regulations, the Fair Labor Standards Act, changing the regulations to loosen them or eliminate them will also be subject to less deference. So in that respect as well, it's a double-edged sword. Want me to keep going or see if we can?
Yes, please.
Okay.
You're on a roll.
Second, and again, importantly, Loper does not cast into question prior decisions under Chevron or the pre-Chevron forms of deference I've already mentioned. So importantly, the court states that its holding will not permit the unraveling of all this precedent that was decided for decades under Chevron and its predecessors. The court states, and I quote, "We do not call into question prior cases that relied on the Chevron framework. The holdings of those cases that specific agency actions are lawful, including the Clean Air Act holding of Chevron itself, are still subject to statutory stare decisis despite our change in interpretive methodology. Mere reliance on Chevron cannot constitute a special justification for overruling such a holding, because to say a precedent relied on Chevron is at best just an argument that the precedent was wrongly decided." So in other words, we feared that overturning Chevron would lead to a vast unraveling of all these decades of precedent that had relied on Chevron under the National Labor Relations Act, Environmental Protection Act, et cetera. But the court fairly clearly says that is not the case, that the mere fact that a case was decided under Chevron, deferring as Chevron required, is not enough to say that that precedent should be overturned. And that's important. We have many cases that go back decades. I'll give you just one example: Republic Aviation versus National Labor Relations Act, 1945. The board held that employees have a right to talk about the union in their non-work time and non-work areas, in the break room, for example. That if the employer prevents that, that is interference. That's the statutory term, interference with the exercise of statutory rights. That case was decided under a deference principle no different than Chevron, even though it was from 1945. Had the court not said that merely the fact that the court deferred under Chevron or its predecessors is not enough to question precedent, you can see the kind of unraveling which would have been possible. So that limitation is important. Thirdly, the court does carve out certain exceptions where greater judicial deference is still merited. And the size and scope of those exceptions is what we're going to be litigating for the next few years, for sure, in various areas. So the court recognized that deference remains appropriate where Congress has expressly delegated authority to an agency. So in other words, in Loper, the court rejects a presumption, right? Under Chevron, we presumed that if a term in a statute was ambiguous, that Congress intended the agency to construe the term. That's what's rejected in Loper. But the court said if Congress is explicit in its delegation of authority to the agency to construe a statute, that would require deference, right? That explicit instruction of Congress should be deferred to. So the court says, quote, "In a case involving an agency, of course, the statute's meaning may well be that the agency is authorized to exercise a degree of discretion. Congress has often enacted such statutes. For example, some statutes expressly delegate to an agency the authority to give meaning to a particular statutory term. For example, for us labor lawyers, prime example is the Fair Labor Standards Act. The so-called white-collar exemptions, supervisor, administrative, executive employees, all state explicitly in the statute that it's up to the wage and hour administrator to, quote, define and delimit those terms. And in fact, the court in Loper cites the domestic service provisions of the act, which also says that the administrator has authority to define and delimit the terms as an example of an express delegation. And the court does not limit the exception to that narrow form of express delegation. Rather, it cites with approval a law review article by Justice Scalia describing the pre-Chevron judicial approach as identifying such express delegation on a, quote, statute by statute basis. So the court states, quote, some statutes empower an agency to prescribe rules to fill up the details of a statutory scheme, or to regulate subject to limits imposed by a term or phrase that leaves agencies with flexibility, such as appropriate or reasonable. The court continues, when the best reading of a statute is that it delegates discretionary authority to an agency, the role of a reviewing court under the APA is, as always, to independently interpret the statute and effectuate the will of Congress subject to constitutional limits. The court fulfills that role by recognizing constitutional delegations, fixing the boundaries of the delegated authority and ensuring the agency is engaged in reasoned decision-making. So in other words, going forward, what does it mean? We're gonna have to look at a statute by statute, and that we're gonna have to engage in a statute by statute analysis of what Congress has said is the agency's role. And there'll be a continuum between what's been rejected, that is merely an ambiguous term, and what's clearly stated, which is if Congress expressly delegates, as in the FLSA, authority to an agency to define the statutory term, those are the two poles. But in between those two poles, there's going to be a lot of gray area. And here's an important one for labor lawyers. The National Labor Relations Act directs the board, quote, to direct an election by secret ballot when there's a question of representation. Now, I would suggest that that is a delegation for the board to direct an election and therefore to create the rules for directing such an election. Whether that will be accepted or what exactly the court means in the ambit of this exception is, as I said, what we're going to be litigating. Third, in terms of exceptions, the court makes clear that its holding does not disturb the traditional deference courts give to agency fact-finding. So fact-finding as opposed to construction of the law. It suggests that the same would be true in the application of a statutory term was sufficiently intertwined with the agency's fact-finding, so mixed questions of fact and law. And interestingly, it cites as an example of such a mixed question of fact and law, its 1944 decision in NLRB versus Hearst Publications, which the labor lawyers in the audience will know is a case in which the court held that newspaper boys who delivered Hearst newspapers, even though they were characterized as independent contractors, should be protected by the act. Even though the act protects all the employees, the court said they should be protected. Reversed in Taft-Hartley, but what's important here is the court, at least implicitly, suggested that even though that was very much a policy decision because it was an application of the term employee to particular facts, it might be entitled to some deference. Now, that could be important. As Justice Kagan explains in her dissent, many agencies' construction of the law are made to apply the law to particular facts. The NLRB does it all the time. Kagan continues somewhat skeptically about the extent of this exception. She says, quote, if in drawing that distinction, the majority intends to confine its holding to the pure type of legal issues, thus enabling courts to defer when law and facts are intertwined, I'd be glad. But I suspect the majority has no such intention because that approach would preserve Chevron in a substantial part of the current domain. So she is skeptical about the ambit of that exception, mixed questions of fact and law.
So Craig, I'd like to go on. This was amazing. Thank you. And Fred, I know you've been coming in and out. Is there something, I know you may not have heard all of it. Is there something you'd like to add before we go on to our next question?
Well, I had planned on summarizing Loper Bright, but I assume that we're just diving in now. So that's great. And why don't we just go right to the next question and I'll add in some thoughts as we go.
Perfect.
And I apologize again for the internet outages here. I'm sorry, everybody.
Well, that's part of our modern world, right? We live on Zoom and sometimes it works and sometimes it doesn't. And I have found leaving my video off is somehow the best way to keep the system going. So Charlene, I would like to turn to you and ask you, so what is Loper Bright, the end of deference as we keep talking about it? You know, what does it mean for worker health and safety? We talked a little bit about the NLRB. Craig certainly made reference to NLRB decisions. But what does it mean for worker safety and health in the area that you're an expert in?
Thanks so much. Well, I first want to say that I am not an attorney, so my perspective is not coming from that basis, but is really looking for, how can we as, local COSH groups or, local advocacy groups respond to this decision and the implications behind this decision. One of the things that we have been doing for a long time is advocating at the federal level for OSHA to issue a heat standard. And this is because, as we all know, many workers have been dying as a result of heat exposure. Many others have been made ill as a result of heat exposure. And we feel and have felt that OSHA needs to take action. And for many years during Democratic administrations, I will say, we have had COSH advocates in the position as heads of OSHA, right? So we've had allies in that office. And that has been tremendous for us. Dr. David Michaels was a founder of NICOSH and was the former head of OSHA. Doug Parker, the current head of OSHA, was the head of a California-based COSH group, right? So we're very entrenched in leadership at the OSHA level. But one of the pieces that I'm aware of is that we at the local level need to do what we can to protect workers in the event that federal agencies will no longer be able to rely on the expertise that they have and their ability to make standards. So as I'm giving this example of a heat standard, I would say that the Temp Coalition that we are leading in New York State to push for extreme temperature standards is more relevant now than ever. Because we don't know what's going to happen at the federal level. Of course, we don't know what's going to happen with the elections, but even putting that aside, I would also say that there's an exercise that I would encourage. I see a lot of my friends in the nonprofit industry here as well, and there's an exercise that I would encourage us to go through, which is scenario planning. I think scenario planning is really important right now. Not just to say, I know a lot of people when they think about scenario planning, they say, okay, well, what are we going to do if the administration changes, right? So if we go from a Democratic to a Republican administration, that's a useful exercise, but also let's look at who we have in the majority in the Supreme Court and how long we're going to have that majority. And let's do scenario planning regardless of who is in office at the White House. And let's figure out what could the potential be for our, loss of any form of advocacy at some of these agencies, right? Our inability to rely on agencies to issue standards that are going to really impact us. And I know that my national colleagues on the call, I don't do national legislation, so it's easier said than done. But I do think that we have to start relying more on Congress. We have to start relying more on what legislation can be passed so that we're not just relying on agencies to issue rules themselves. We have to be more specific when we're passing legislation, right? We can't leave anything up to the agencies anymore as much as a strategy that has been in the past. I think we need to work with a certain degree of specificity. And I'll leave it there and pass it back to you.
Charlene, you talked about national legislation. What about New York State legislation or local legislation within the states? Since you talked about the fact that you work really in New York State, what about that part of the puzzle?
I think that we need to be advancing state-based legislation in whatever way we can. I don't think we should worry about preemption. We should try to work around it as much as we can, of course. But I think that we need to be pushing state-based legislation on extreme temperatures. I think we need to be pushing state-based legislation on areas where OSHA does not currently have laws. For example, RWDSU, the Retail Wholesale Department Store Union, just passed legislation as it relates to line speeds at warehouses. And that's something that can be done at the state level. Mandating ergonomists to actually go to these warehouses and figure out what standards make sense, and making sure that each warehouse has a plan in place, right? These are things that we can do at the state level that I think maybe we weren't thinking about as creatively in years past, but now we have to be thinking about what can New York State do to really protect our state. And I think it's the same for other issues. We should be looking at movements like the reproductive rights movement, right? How are states going about to protect reproductive rights right now? And how can we, kind of think about the same level of protections in the worker safety and health arena?
Thank you. Fred or Craig, is there anything you'd like to add to what Charlene has said in terms of focusing on the states before we go back to the federal government? Because I'm going to go back to the federal government in a minute, but I wanted to know, did either one of you have anything you wanted to add with respect to state action? Certainly the NLRA, we have federal preemption, but there are other statutes like wage and hour, which there is no federal preemption. So anything you want to add here before we go on?
Fred,
Yep.
go ahead.
I was going to let you go ahead because your jurisdiction is far broader than mine, Craig.
Well, can I answer a slightly different question? Because I think there's an important piece that we've left out, given the dance back and forth with Fred and myself, and it very much relates to the OSHA and safety and health question, which is Loper, importantly, did not eliminate deference. It substantially reduced deference. It overturned the strong form of deference established by Chevron. But in its place, it put something called Skidmore deference, which is from an old FLSA case called Skidmore versus Swift, where the court said that the court should defer to agency constructions. Here, a question of what is work, was waiting time work or not work in a packing house, to the extent essentially that the agency's decision deserves deference because of its strength of its reasoning, because its consistency over time, because it was promulgated shortly after the statute was adopted, or importantly, in relationship to agencies like OSHA, the court said that the agency's interpretation, quote, may be especially informative to the extent it rests on factual premises within the agency's expertise. So OSHA, EPA should continue to receive significant deference because of that expertise, which goes beyond construing what the language of a statute means and relates to scientific and other fact-finding. So I do think you'll see, hopefully, continued deference to those expert agencies. OSHA also has very broad statutory language, right? OSHA is supposed to adopt standards reasonably necessary, appropriate, to provide safe or healthful employment in places of employment. That may be the kind of delegation the court would recognize to adopt standards to construe that very broad language, really reasonably necessary or appropriate. So I do think OSHA will continue to have some powerful arguments for not Chevron deference, but Skidmore deference.
Thank you, Craig. So I'm going to turn back to you, Fred.
Yes.
So under Loper Bright, how does the NLRB carry out really its congressional mandate to establish a national labor policy? That's what the preamble talks about, a national labor policy. Are we going to have a patchwork of different standards depending on what circuit the employer is located or the employee is located? How is the NLRB, I know it's a recent case, the case just came down at the end of the Supreme Court season. How's the NLRB looking at this, given that your mandate is a national policy, but now we're talking about things needing to go in the NLRB world, it'll go to the Court of Appeals, clearly not to the federal district court because the board is also adjudicate. So how's the NLRB looking at this?
Well, I mean, I think you've hit the nail on the head. The board since 1935 has felt very strongly that it is in charge of national labor policy. That was the point of the Wagner Act. That was the point of creating a federal system and recognizing that all our economies from one coast to the next, from the West Coast to the East Coast and from the North to the South, and are all connected. And that disruptions to our economy that are caused by labor can not just affect you in the 11th Circuit or the 5th Circuit or the 9th Circuit, but they can affect you anywhere. And that they all, like dominoes, one falls and they all fall. So it's extremely important to the board, and I can't see the board in any way surrendering its role that it was assigned by the Wagner Act, by the Taft-Hartley Act, to create national labor policy. So what is the board trying to do right now? And the answer is it's in flux because it's such a new decision. And, I think the one indication we have is that we've received congressional oversight from the Hill, and they asked us, what are you going to do now that Loper Bright is out? And the board just responded on Friday. The chairman sent a letter, our Office of Congressional Public Affairs sent a letter to the Hill, basically saying that to ensure that our orders comply with applicable law, we will continue to approach our work as we always have, which is hewing to the text of the NLRA, respecting precedent, and thoroughly explaining the grounds for our decisions. And, ultimately under Loper Bright, as Craig just mentioned, deference is not abandoned. It is just, it's slightly transformed. It's a different kind of deference. And doing exactly that, hewing to the language of the act, hewing to precedent, hewing to thoroughly explaining decisions is what the board will need to do to be successful under Loper Bright. I would note we've received a whole bunch of supplemental letters in pending cases from parties, essentially suggesting to the courts that we're owed no deference. A brief was filed that received a certain amount of press last Friday in a case out of the 7th Circuit involving Amazon, where Amazon's counsel argued that the deference regime involving the board is completely out. And all of those are public documents. We haven't had a chance to reply to them, but I assume our incredibly talented appellate court staff will be replying to those in due time. But what I will note is this as well, that since Loper Bright was issued in June, we have received 5 or 6 board decisions from the courts of appeals, and each one of them has adhered to what we're calling non-Chevron law, sort of the law that involves the pre-existing deference that the courts have given to the board since 1941. Just yesterday, the 7th Circuit issued a decision saying that for legal conclusions, our scrutiny of the board's decision is deferential for exactly the reasons that you pointed out, Esther, out of respect for Congress's broad delegation of responsibility for developing national labor policy to the board. So we are hopeful that there is a lot of precedent out there going very far back that will remain meaningful despite Loper Bright and the challenges that it provides.
So can I ask you before I move to someone else, another sort of piece of the puzzle that I remember quite well, which is the board only accepts Supreme Court decisions. So if your region is located in the 3rd Circuit and the 3rd Circuit says the law is X, but in the 2nd Circuit and the 8th Circuit, the law is something else, the board adheres to its own law until the Supreme Court has spoken. Will Loper Bright change that in any way?
I can't speak to what the board will do. That is for the people who've received a commission from the president. But in the past, any changes in the deference regime, whether it was the adoption of Chevron or how it was changed in Meade or any of the many changes we've seen since 1935, the board has always adhered to its policy of what we call non-acquiescence. And that is because, again, Congress charged the board with establishing national labor policy. and for, you know, ultimately for the resolution of these really difficult questions of law and fact and labor policy that the courts are inevitably involved in. It's good to have lots of different court decisions because it's good for the Supreme Court to receive not just the wisdom of the board, which of course we think is, you know, going to be the most wise, but also the decisions of, or I think is the most wise, I'll put it that way, but also the decisions of numerous different courts, and let those issues percolate so that the Supreme Court can see different viewpoints. And the Supreme Court has said that's a really positive point, a positive aspect of having multiple venues for board decisions and other agency decisions. So we will see what happens. I can't speak to what the board will do, but if passed as prologue again, I would imagine non-acquiescence will continue to be the board's policy.
Thank you. Charlene, I'd like to go back to you again, talk a little bit more about occupational safety and health. And that statute, the OSHA statute, gives OSHA it's a broad delegation, again, a statutory power with respect to safety and health. So what more would you like NICOSH to be thinking about? You started to speak about it a little bit earlier, but what more would you like NICOSH to think about and the local COSH groups about what they do on a national level? What support perhaps OSHA should be given from the local groups? And how we should think more about local law. So can you speak a little bit more about sort of the federal system first in terms of what the COSH group should be doing perhaps?
Mm-hmm. Yeah, thank you so much. I mean, I think that at the national level, right, when we think about OSHA, because OSHA has been you know, COSH organizations were fundamental along with Tony Mizaki and many of our other heroes in the labor movement towards making OSHA a reality, right? And towards, you know, making OSHA an agency that we really felt like was going to protect workers. And I think that for folks who've been at this for a long time, it kind of comes as a bit of a shock to kind of realize that the way that OSHA has protected workers could be being challenged, right? And the ability of OSHA to further protect workers could be weakened. I think that's somewhat of a shock. And it, like I was saying earlier, you know, we have to be in a position where we are not surprised anymore. You know, our jaws cannot drop when we see that Roe v. Wade is overturned. You know, I was part of conversations in the reproductive health space where people had been talking about how Roe v. Wade was going to be overturned, right? And it's similar, I think, with Chevron, right? Like we were, you know, Esther, you put this panel together before the Supreme Court issued its decision. So people are, right, thinking about, you know, what is going to happen and what are the decisions that the Supreme Court is likely to make. So again, I think we need to, at the national level, go through these exercises. You know, let's think 10, 20, 30 years into the future and think about what is the state of occupational safety and health going to be. And I know that it's devastating. I know that it's devastating to think about what we could lose. But that doesn't mean we should shy away from those strategy conversations. It doesn't mean we should shy away from thinking about what we could do that is protective. And then, you know, just in terms of like, what happens now with OSHA, I think that there, you know, I have questions, you know, this panel definitely brings out some questions for me, but I think that, you know, one piece that we know is that, you know, OSHA might lose some ability to, you know, interpret ambiguous statutory language, right? We know that that's possible. We know that there could be a slower rulemaking process. I mean, Lord help us, OSHA has a very slow rulemaking process now, but we know that this process could be slower. I think that there's a potential as I'm talking now, I'm talking about like, you know, potentially like being devastated. I think there's potential that we have weakened enforcement power. You know, courts might be less likely to defer to OSHA's interpretation and enforcement actions. That's a possibility. I think that, you know, is potential congressional action, right? Congress might need to provide more specific statutory language to support OSHA's authority. And I think that there's a window there. Of course, it all depends on what we think is possible at the federal level, but I think that we have a window there. And then I think also that there's a shift in regulatory strategy, right? So OSHA might need to rely more on guidance documents and interpretive rules. And I think that is all on the horizon for what we should expect. Now, I have never worked at OSHA, I will say that. And for my friends over there, I think that, the conversations that I've had are conversations of concern. I think that people are, I don't want to put words into anyone's mouth because we don't have anyone at OSHA here, but I think that people are concerned, and that's putting it lightly. Some people who have, recently retired from OSHA or have recently left OSHA have been more blunt about saying that this could be a disaster for worker health and safety. So I don't want to be alarmist, but I think that, again, we need to do that scenario planning, and we need to be thinking about, in blue states, what can we do to protect workers proactively?
Thank you, Charlene. That adds to the conversation. Thank you very much. Craig, you may want to respond to some of the things Charlene said, but I would also ask you to really talk about another Supreme Court decision that came down at basically the same time, and that's Corner Post. Can you briefly sort of describe the holding in that case and why Corner Post and Loper Bright sort of fit together as part of what I see? I don't want to put words in anyone's mouth. What I see as an attack on the administrative state. There've been a lot of discussions about, the deep state. So to me, this looks like it's together. It is an attack on the administrative state. And then I'm going to say a two-part question. And then the next part of it is, what's next? What's next on the attack on the deep state?
Okay, let me take the first part first. So Corner Post, as Esther just said, was another decision issued at the end of the last term, another 6-3 decision with the same partisan alignment. And it held that the 6-year statute of limitations for challenging agency rules does not begin to run, when the rule takes effect, but rather when the rule is applied to the particular plaintiff. So the court reasoned that the statute of limitations was not a statute of repose. That is, it was intended to give all plaintiffs a fair opportunity to challenge the statute, not simply to promote the finality of the government's action. So what does this mean practically? It means that long-standing agency rules can be challenged. So here, the plaintiff, Corner Post, was not even in business at the time the rule went into effect. So when the rule was applied to Corner Post years later, the court holds it can challenge the rule. It's not barred by the statute of limitations. Now, like Loper, that doesn't mean it wins. And it doesn't mean that prior decisions upholding the rule are not binding precedent. So that's parallel to Loper. So the challenge of Corner Post is not barred by the 6-year statute of limitations. But if the rule has already been upheld by the circuit in which the challenge is brought, by the Supreme Court, those are binding precedents. So that's an important limitation on Corner Post, just as in Loper. So again, it broadens the field for challenging agency actions here temporally, in Loper in terms of deference, here in terms of time. It is part of a larger attack on the so-called deep state, or the administrative state, or the New Deal in which most of these agencies were created. This court is very jealously guarding executive power, but executive power located in the White House, not in the executive agencies. So it's limiting the power of the executive agencies and expanding the power of the president in the area of agency action, as I'll talk about in a second, but also obviously in the area of immunity and other areas. So what's next? I think what's next is already upon us in some ways. A couple things. One is in the area of OSHA, there's already been an attempt to revive a pre-New Deal a doctrine called the non-delegation doctrine, which says that Congress cannot delegate its lawmaking power to agencies. Right? This court is very categorical in terms of the judiciary has its function, the legislature has its function, the executive has its function, and they shouldn't be mixed. So there's been an attempt, which the court denied cert in this last term with the dissent by Justice Thomas, to say that OSHA is too broad a delegation. The language I quoted earlier gives OSHA too much legislative power. Now you see the potential squeeze play at issue here, right? We'll recognize delegation and therefore defer, but too much delegation may be unconstitutional. So the revival of that non-delegation doctrine is one thing which may be next. Secondly, the independence of agencies is already being challenged. The fact that board members can't be removed without just cause, the fact that administrative law judges cannot be removed without just cause. That's being challenged by SpaceX and other litigants right now, not only relating to the National Labor Relations Board, but other agencies as well. The notion is the so-called unitary executive, that is, the president has sole constitutional authority to see that the laws are faithfully executed, and that can't be interfered with by Congress by giving executive branch agencies protection against the president, board members, administrative law judges, et cetera, that their just cause protection conflicts with that that constitutional principle of a unitary executive. So there's two doctrines that are already at issue. The third one I just mentioned briefly is the right to a jury trial. So as everybody knows, agencies don't conduct jury trials, courts do. And yet the argument is that some agencies cannot impose certain sanctions. In the last term, the court held in a case called Jarchese that the SEC could not impose a penalty without a jury trial, that it violates the Seventh Amendment, and similar arguments are being made in relationship to the board. So a multi-pronged attack on administrative agencies is what we can expect.
So, Fred, is there something you'd like to add to that? You're on mute.
At least mute is easy to correct. I have some very strong thoughts about the deep state personally, and I will just add that I've worked in a lot of federal agencies. I've worked for the Army as a civilian employee. I've worked in the judiciary. I've worked at the NLRB. I've worked at the FLRA, and I've met people all throughout the government. And one of the really meaningful things about being a public servant is that people are truly dedicated to public service and to providing honest, fair, candid advice to the political folks who the president appoints to lead our agency. So anytime I hear the term deep state, I want to jump up and defend the civil service, because I think, they are doing an incredibly important and valuable role that keeps our government running. I will refrain from commenting broadly about attacks on the deep state, and I think, Craig is right that these are all concerning decisions and issues that are percolating in the courts of appeals that the board is litigating right now, and we will see how they play out. But, to piggyback on Charlene's point that we all need to be thinking creatively, like any litigator, about arguments that could come down the pike. And I would say that to any administration that is working at the board, that we need to be really creative and thoughtful about how the courts think about administrative agencies, because we're not living in the era of the 1960s and 70s DC Circuit that really embraced the New Deal concept of administrative law.
Thank you, Fred. Charlene, is there anything you'd like to add on this? Because actually you get the next question. So is there something you want to add about the administrative state and OSHA or administrative state in general?
I think that a lot of times when we think about the administrative state, we don't always think about how protective the administrative state can be, right? And when you think about the possibility of losing some of those protections, I think some of us get scared and we're like, well, what happens now that we're losing some of that? Because we know that, you know, I'll call them rank and filers, right? The rank and filers in the administrative state helped protect us against a lot of toxic, you know, new policies that were coming out, you know, in I'll just say the year in 2020, 2021. So I think, excuse me, in 2016, 2017. So I think that, you know, from my perspective, we have to do everything that we can to support these folks, to support, you know, these rank and filers who are doing everything that they can. But I'll leave it there. I have more opinions, but I'll leave it there.
Okay, well, now I'm going to ask you to give us an opinion, but in a slightly different question. Let me phrase it this way. Craig has talked about it and Fred has talked about it, and it really is the role of expertise. And so my question is, how can an agency like OSHA, you know, working in a highly technical area, convey to the court their institutional knowledge? This really is about the deep state. Their institutional knowledge. How does that happen so that the court sees the knowledge that OSHA or any other agency with institutional knowledge can bring to the court to defend its decisions and its fact finding?
So first I want to talk about, you know, the way that I assumed that the agency would be able to convey its expertise in the past, right? So there was a presumption of expertise, right? Chevron deference is fundamentally based on the assumption that agencies possess specialized knowledge and expertise in the regulatory domains. And this presumption allows agencies to interpret ambiguous statutes within their purview. So what about now, right, is my question. There's also, you know, flexibility in policymaking. It gave agencies more latitude to adapt their interpretations of statutes to changing circumstances, to technological advancements or new scientific understanding. What about now? The incentive for a thorough analysis, right? Agencies are motivated to provide detailed, well-reasoned explanations for their interpretation, and to demonstrate their expertise and increase the likelihood of receiving deference. What if that's not enough? Right? The emphasis on agency process, right? Courts often look at the process by which an agency arrived at its interpretation, placing importance on the agency's use of its expertise in decision-making. Will this process be followed? You know, balancing political accountability and expertise. Chevron recognized that agencies as part of the executive branch have a degree of political accountability, while also protecting technical expertise. Do we think that the courts are going to have this technical expertise now, right? Do the courts have the ability, I'm just being sarcastic, but do the courts have the ability to, you know, interpret a heat standard, right? And then finally, like the impact on agency behavior, right? Agencies may be more confident in making broader interpretations of their statutory authority, or they may have been, knowing that the courts were likely to defer to their expertise. How will agencies kind of convey that confidence now? So not to state the obvious, but of course there are the ways that, you know, agencies have always shown their expertise that I think we can partially rely on. The amicus briefs have always, you know, been a way for agencies to show their expertise. I think also detailed administrative records, right? When agencies' actions are being challenged, kind of showcasing the administrative record, what the decision-making process has been. Having expert testimony can be helpful. The regulatory history, you know, technical explanations, providing really clear, thorough explanations of complex technical matters in court filings. You know, I think that sometimes we work in specialized fields and we don't realize just how technical we can be. So making sure that that technicality is really conveyed in a way, like I always, whenever I'm trying to talk about how to give trainings and how to talk to workers and how to, you know, kind of make our points to a broader audience, I always say, assume someone knows nothing about what you're talking about. And I think we have to go back to that, right? Like assume that a law clerk is reading your technical testimony. And that is who you have to, like, you know, base this on. You know, citing scientific studies, referencing peer-reviewed studies and research that support the agency's position to bolster its credibility. And And I have a couple more, but like really consistency with past practices, right? So highlighting how current actions align with established agency practices and can demonstrate longstanding expertise, I think could be really helpful. Now these are my non-lawyer, kind of opinions, but I'd really be curious to see how other people feel about this.
So Fred and then Craig, anything that you'd like to add to what Charlene just laid out for us in terms of
mean,
expertise in demonstrating it?
I think expertise is really important. That's why we have administrative agencies, right? Because Congress doesn't know everything, and it knows what it doesn't know. And it knows that there are experts out there who can make these decisions. And that's why we created administrative agencies, dating back to the Interstate Commerce Commission in the 19th century. I mean, we're not just talking about the New Deal. We're talking about going back to, the post-Civil War era. As Charlene said, and Craig probably said it while I was fighting the internet, one of the interesting things about Loper Bright is that it really adhered to the fact that the APA says policymaking and fact-finding are still entitled to deference, both under the APA and certainly under the NLRA statute. And so once you're in that world, the role of expertise is really apparent. And I think for all the reasons that Charlene said and reasons that Craig said, as we're applying sort of Skidmore deference, like what is the agency's view worth, expertise has always been a critical component of that. If I'm going to play Pollyanna, and sometimes I play Pollyanna and optimist, so if I'm too optimistic, you all should yell at me. I've been thinking about deference and this idea of, if you bear with me, I'll do this quickly. Grade inflation, right? We all start with, every teacher, I guess, starts saying, I'm going to be really strict, and a C is going to mean a C, and a B is going to mean a B, and an A is really only for the best. But over time, there's a creep. And I think, and this is a lot of academics have written about this, that there is often deference creep, that we will kind of try to reboot it here with Loper Bright. But over time, what will happen is a district court will be truly confronted with the question of, is this squirrel endangered species for the purposes of the Endangered Species Act, as Justice Kagan, I think, notes a similar example. That might be the example she knows to send. And they will throw up their hands and they will say, I don't really know the answer to this question. I'm not a squirrel expert. I'm not a heat standard expert. I'm not a stationary source expert. And you end up kind of rebuilding law that gives deference to agencies. So I think for the board, what I see personally is that I think labor law is really hard, actually. I've been practicing it for a long time. I don't think it's easy. And I think if you go back to the early days of the Act, you see why it's really hard. And so what I imagine parties will litigate is, and as I said earlier, what we told Congress is that we are going to make an effort, as we always have, to thoroughly explain the bases for the board's decisions. And part of that is showing why it takes an expert opinion to reach the results we reach.
I just want to point out to everybody that, sorry, that when you refer to the APA, it's the Administrative Procedures Act. Not everybody might know the APA, so I just to make that clear. Craig, is there, before we go to sort of our last question and then start to look at what we have in the Q&A, would you like to add something with respect to expertise?
Yeah, well, I think just to summarize what I think is coming out of our discussion, I think we're going to have two hotly contested areas post-Loper. One is, what's a delegation? When has Congress actually delegated interpretive authority to an agency? What language is necessary in a statute beyond the obvious language? That's one. And secondly, I think what Charlene and Fred were just describing is, we do have Skidmore deference and it does respect expertise, but what is expertise? I think we all agree on the obvious examples: empirical, scientific expertise, OSHA, EPA. But what about the National Labor Relations Board? So, Justice Kagan has some language in her dissent where she's saying Congress might, quote, value the agency's experience with how a complex regulatory regime functions and with what is needed to make it effective. That's really what the board has. The board does not conduct empirical examination of its assumptions. The board is not a scientific agency, but it does have experience with a complex regulatory regime and what's needed to make it effective. I think, despite Fred's somewhat sanguine view, some courts are not going to accept that type of expertise. And that's where the battle lines are going to be drawn, right, under Skidmore. What is the type of expertise which courts will respect and what isn't?
Well, I guess we'll find out. I'm thinking of all the other statutes and all the other agencies. I'm thinking about the EEOC and discrimination. I'm thinking about, the Equal Pay Act, age discrimination, thinking about the Americans with Disabilities Act and how difficult the questions are about defining a disability and the requirements of that. So there's so much here for us to think about. So before we turn over to some of the questions in the chat, I wanted to, this conversation's been taking place with a lot of legalese. I know Charlene, you're the only non-lawyer on the panel, and I appreciate the fact that you were willing to put yourself in a position to be surrounded by labor and employment lawyers. The question is, what do we want to tell the average worker about what this means? How is this going to impact the average worker? What do we want that person to know as we go forward here? And I don't know, Charlene, do you want to start us off with that? In terms of, if you were sitting down with a group of workers, what would you tell them about this? What do you want them to know?
Yeah, thanks so much for this question. And I think that, as NICOSH, that's what we're always thinking about as an education and training and advocacy organization. But we train about 10,000 workers every year. And, our focus is always, how do we kind of get workers to think through some of the problems that we're facing, and how do we activate those workers towards being involved in the solutions. So I think that, one thing that I can concretely say is that we have a lot of workers in our base who were so excited when OSHA came out with its proposed rulemaking around the heat standard, right? And these are folks who've been involved in advocating for the temp standard at the state level. And they're like, okay, this is great. Now we don't have to fight for, the temp bill anymore. Kind of mission accomplished. It's giving that vibe. You know what I mean? So I think that, what we've tried to tell people is like, look, this is going to mean potentially slower implementation of new safety rules, right? Like things might take a little bit longer. The existing regulations that we see might face more legal challenges. And, there could, potentially be, a possible reduction in protective measures in some workplaces. So, let's keep steady. Let's keep a steady hand on the advocacy work that we're doing here. And never has our campaign been more important, to pass a statewide standard that addresses extreme temperatures than it is now. So, just really, I think having folks like, celebrating the victories, right? Even the small things, celebrating what we've won, but also keeping our eye on the prize so that workers don't have to work in 95-degree heat on the top of a roof of, a Manhattan building, right? So just like keeping our eye on the prize and making sure that we know that, and that workers know that, yes, OSHA's rulemaking is a step in the right direction, but we're not exactly clear how soon that might be implemented in the fields and what that's going to look like.
Thank you. Craig? I know you don't speak to the whole AFL-CIO, but from the perspective of the labor movement, what do you want workers to know about this?
Well, as you started in your introduction, we filed a brief in support of Chevron Deference. And although I started my remarks by saying this is a double-edged sword, which it is at times, overall, this is not a positive development. In time, this is going to weaken the authority and the power and the ability of the federal government to protect working people. There's no question about it. Congress cannot anticipate every circumstances. Congress cannot predict the future. And it used to be that administrative agencies had not only the authority, but the duty to adapt the law to changes in the economy and in the workplace. that is going to be much more difficult under Loper. So over time, federal statutes are going to become outdated. They're not going to apply to new circumstances, and they're going to become less effective. So I think the lesson that has to get taken away is that organizing, forming unions, protecting oneself through collective bargaining is going to become all the more important.
Thank you. Fred, with your hat as solicitor for the NLRB, what do you want? I think we just lost Fred again. Okay,
I'm
maybe
still here.
Fred. Oh, there
I'm
you
still
are.
here.
You
Yes. I
just
think
moved
Craig
on
went
my
off screen.
screen. You
Yeah.
moved on my screen. Yes, so from the NLRB perspective of the agency that enforces the act, which says that employees have a right to join unions and engage in collective bargaining and engage in protected concerted activity, what do you want workers to know about this decision?
I mean, what I would say is this. Again, maybe I'm wearing my Pollyanna hat, but I would let people know that the NLRB is still open for business. I can't argue or with Charlene's observation and Craig's observations, there are lots of legal challenges or legal aspects of this decision that will make or could make, I will say. Let me even put it a little bit different. That will give many parties an opportunity to arrange to try to make things difficult for federal agencies to achieve their mission for all the reasons that Charlene and Craig have observed. But at least for the board, and I would imagine it's like this for other agencies, a recent study showed that only 2% of board decisions engaged in true statutory interpretation. Application of law to facts, which is really the bread and butter of what the board does, we still receive deference for. Fact finding, we still receive deference for. And at least when it comes to the traditional bread and butter work that we do, I don't want employees to be discouraged or to think that the board's not going to be there for them to protect their rights. And I would imagine my colleagues at the EEOC and OSHA and other agencies would say the same thing. And I say that again, not to dismiss the legal difficulties that this decision may end up posing for federal agencies, but to more try to be a reassuring voice that so long as that statute is there, the agency is going to be doing its best to protect the workers the statute's intended to protect.
Thank you. We have several questions in the Q&A, which I would like to ask the group to respond to. So here's one of the questions. Do you think there are rules, regulations with regard to the Fair Labor Standards Act? Are these now vulnerable? There was a back and forth for the independent contractor test under Trump and now Biden. This is exactly, I think, Fred, Craig, what you mentioned with the change in society, in terms of we're having new groups of employees all the time now. And of course, we have the whole tech industry as well, which is a very different industry, and independent contractors. Yes, I know the newsboys were called independent contractors in the Hearst case, but nevertheless, the world has changed dramatically. So the back and forth for the IC test under Trump and Biden, I am wondering whether the exemption, whether salary range or companionship, which was important in the NDWA, could be vulnerable to lawsuits from business groups. So this is about, for everybody, this is about the Wage and Hour Division of the U.S. Department of Labor, which enforces the Fair Labor Standards Act. Craig, maybe you want to take this one?
Sure. So there's a whole bunch of parts of that.
Yes.
One is that there's a very big difference between the Wage and Hour Administration and the NLRB in terms of whether they proceed by rulemaking or adjudication. So in terms of the DOL and the Wage and Hour Administrator, they typically proceed by rulemaking. So corner post is important. Right? Some of those rules which have been upheld previously could be subject to challenge now because of corner post if they're applied for the first time to a new employer. Not to say that precedent would not still be binding, but it wouldn't be barred by the statute of limitations. Might some of those rules be more vulnerable? Maybe. although several that the question mentions, including the companionship exemption, how it's construed, there is a clear delegation in the statute, which gives the wage and hour administrator clear delegated authority to define and delimit the term companionship services. So I think that is not going to be subject to any heightened scrutiny. The independent contractor, finally, the independent contractor rule, again, there's a difference between the boards back and forth on the independent contractor and also other definitions of employee and wage and hour administrator in terms of whether the statute adopts a common law test or not. The board, the courts have held, is not entitled to deference, even when Chevron was in place, in terms of how it defines the term employee, because it's a common law. The statute has been construed to adopt a common law definition, and courts believe they know more about the common law than the NLRB. The wage and hour administrator is different because of the way the Fair Labor Standards Act definition of employee has been understood. So that's a long way of saying it really depends. Some of the wage and hour administrators' rules are going to be safe, or at least as safe as they were before Chevron because of an express delegation. Some may be more subject to more scrutiny.
Thank you. Any, Fred or Charlene, do you want to jump in on this one? Okay. Well, here, this is a question, it was our first question that came in. Will this decision affect safety and compliance standards already in place? So were OSHA standards already in place be impacted, and will the ability to file complaints with OSHA be impacted as well? I think this got touched on, you touched on a little bit, Craig, and I think you did also, Charlene. I think it's about what's already in place is the concern here. One of you want to respond to that?
I'll let Craig respond, as I'm not the lawyer.
Well, I mean, I think, in terms of complaints, I would echo what Fred said. None of this should be in any way be a deterrent to anyone exercising their rights or seeking protection. No worker should hesitate to file a charge with the board or a complaint with OSHA or charge with the EEOC. The laws remain in effect, the rules remain in effect, the regulations remain in effect. Now, are existing rules potentially subject to challenge, which were not subject to challenge before, either because of corner post or because of a reduced level of deference? Yes. Does that mean those challenges are going to be successful? No. We have arguments for deference. We have arguments that precedents are still good precedents where those rules or regulations have been upheld. We have arguments for deference under Skidmore, the type we've talked about, experience, expertise, etc. So no one should hesitate to exercise their rights as they have in the past. Are new avenues of challenge open? Maybe, but there's certainly counter arguments to be made.
Okay, we have another question which compares state agencies and federal agencies. And I think the question really is, how do we protect deference in state agencies other than having the legislature expressly giving deference to an agency? So I think this person is looking at the states, and we have many of the same agencies in the state that we have in the federal government, except certainly for the National Labor Relations Board because of preemption. So is there a way to protect it on the state level? Do we need the legislature to have a express standard of deference? Any of you want to try to tackle that?
I'm stepping far outside my area of expertise, but
Okay.
I will say that at least the studies seem to show that there's a fair amount of variation on the state level as to deference. Some states have parroted Chevron, some states have completely rejected Chevron, some states have a very happy mashup of Chevron and Skidmore. So there's it's a really interesting laboratory to see how different deference regimes affect administrative agencies. And, I think, and legislatures, because they tend to be a little more nimble in the states than the federal government, have indeed also experimented. Some have banned Chevron altogether, that kind of deference, and required states to be de novo. So it is I guess like I said, I'm going out on a limb outside my area of expertise, but I will say the question, I guess I'm just basically praising the question because I think it's a really good area for folks to think about, to think how different models could affect the ability to protect worker rights, and other regulatory regimes.
Okay, thank you, Fred. So someone has asked a question about Title VII. And I know that, Fred, you're at the NLRB. And so you don't have anything to do with enforcing Title VII. And Craig, you looked at all labor and employment law, and Charlene, your occupational safety and health. But the question is, and I just want to make sure we even begin to think about it, just as you just raised it, Fred, have any of you done analysis related to Title VII? And I would add Title VII, the ADA, all of the panoply of laws that are enforced by the EEOC. Would love to hear any general thoughts about delegation to that statute.
There's certainly going to be implications. The implications, as we said throughout, are going to be statute by statute here. So we're going to have to look at Title VII. We're going to have to look at the ADA. We're going to have to look at other anti-discrimination and employment laws to see what exactly is the language which gives authority to the EEOC or other bodies. Title VII is different, of course, because many cases are never adjudicated by the EEOC. Most cases are not adjudicated by the EEOC. So unlike the NLRA, where the board has the first crack at applying the law to the facts, I think generally there's been less deference because there is so much judicial construction of Title VII. But the same principles of deference apply. Our LOPR has now weakened deference, but as we've said, it's going to be a statute by statute matter to see what exactly the nature of the delegation is, what exact authority Congress has given the agencies, and what arguments can be made about deference based on that.
Fred or Charlene want to jump in on that one?
The one area I would also, and I think is interesting to think about in Title VII, is federal sector Title VII law, where the EEOC does have the role of serving as an adjudicator for federal sector employment, Title VII employment disputes, and they issue final binding decisions that are reviewable in court. And so it might be interesting to look there to see how this could impact. I mean, it's interesting because the EEOC's analysis on Title VII and sexual orientation discrimination first emerged in the federal sector. And so, so it can be very influential in developing Title VII law. I assume the really, really smart people at the EEOC are thinking about these issues right now and how to confront LOPR right.
Thank you. Back to OSHA, and Charlene, maybe you can help us with this and the other lawyers on the panel. The question is, are OSHA's definitions serious, willful, and repeat violations open to challenge? So it's definitional about serious, willful, and repeat violations. Any thoughts, the three of you?
I need my health and safety department here. It goes beyond, but it goes beyond my specific knowledge of OSHA. But I would just say that every statutory term that's been construed by an agency where deference has been granted in the past is going to be subject to some question. Whether there's already binding precedent about what the terms mean, that's going to be important because of what Loper says about not upsetting prior precedent. The exact language which relates to the agency's authority construe those specific terms is going to be important. So every place where an agency has construed statutory language, where contrary constructions are possible, there may be a contest.
And I'll say on my end, just from my experience with these violations, I mean, these have already been subject to challenge and interpretation by courts, right? Before any of these Supreme Court rulings. So for example, courts have sometimes narrowed OSHA's interpretation of repeat violations. Courts have challenged willful violations. So I think that, anything, we can basically use what's happened in the past to assume that this will continue to happen and might not fare well for us.
Yeah, if I could just say one thing, I think Charlene is absolutely right. And it's something we should have said previously, which is we should not exaggerate the degree of deference which existed before. I'm sure Fred would love to speak to that in relationship to the National Labor Relations Board. That is, Chevron was one thing on paper, but it's not as if courts would not step in when they wish to do so, particularly the Supreme Court. So, we should take the language of Chevron with a grain of salt in terms of what actually happened in the courts, particularly the Supreme Court.
And just finally to add, I think that I believe it was Massachusetts Kosh issued a report as it related to employers who contest a violation, right? And the ways in which employers have been able to reduce the fines that they're paying strategically so that they continue to contest violations. And I think that one thing that I worry about is that, if an employer does contest a citation, could these definitions then be challenged in court? And, is that a potential risk as well? Will employers take advantage of that?
Fred, do you want to respond a little bit to the point that Craig raised about the fact that the NLRB hasn't always gotten a great deal of deference from the courts?
For many years, the board says we have said things like, we have an enviable record in the courts of appeals. I think we generally do. The board's appellate counsel is incredibly talented, and they do a great job. We tend to win the vast majority of cases, in full or in part, that go to the courts. I would imagine, though, that after a couple of drinks, if we talk to appellate counsel, including me when I was appellate counsel, there would be a number of conversations about when we wish we got more deference. So, Craig is absolutely right that Chevron said one thing, as did Beth Israel, which was a very important case about deference to the NLRB, and Hearst, which the Supreme Court cited favorably, and Loper Bright, all said really wonderful things about deference to the NLRB, but judges are people, and they may not always rule the way you want them to rule. So there are really interesting studies on Chevron deference in particular that have been done in the last number of years, and how it curbs or doesn't curb judicial decision making. And while there certainly seems to be empirical evidence that Chevron did reduce the amount of sort of what one might consider judges bringing their priors to cases, it didn't completely eliminate it, to Craig's point. So, it's why the board, again, like we're going back to first thing I said, like, it doesn't matter what deference is, what level of deference we're getting. Anybody who litigates on behalf of any federal agency is going to do everything to make their argument as convincing as possible, whether you're writing from the time the board decisions are written, to make them as thorough, smart, empirical, and grounded in law and text as possible. And appellate counsel will do the same thing, because I think, Charlene, you're the one, I think you said, you don't know who your judge is going to be and what their experience is in any particular area of law, labor, OSHA, environmental. And so you need to kind of bring them from first principles to the place where you're showing the true thoroughness of the consideration of the statutory text and application to make your case.
Thank you. Well, this is an interesting question. Will this decision hurt a union's ability to bargain collectively and negotiate contracts and impact the various things that unions do? How is this going to impact collective bargaining and representation of workers that is what unions do?
I think that's perhaps mine in the first instance.
I think so, too.
I don't think there's going to be any impact in the short term.
Okay.
What unions do is based on the collective will of the workers, and typically does not involve the NLRB. Only in rare instances is there a charge. So I think unions are going to continue to do what they do. Sometimes there will be a charge, or in first instance in organizing, there'll be a petition and election, but none of this is going to change anything radically and quickly. There's going to be a set of arguments that we've all described here about what this decision means and where it applies and where it doesn't, and what Skidmore deference is compared to Chevron deference. And it's going to take a long time to play out in the courts. And as I said, it may be helpful to unions if there's a different party in the White House come next January. So in the short term, workers are going to organize the same way. They're going to bargain the same way. It's really going to take us a decade or more to see what the real implications are.
I would just add one thing, which is that, the old saying goes, a bad boss is the best organizer, right? And I think from my perspective, the same is true when government has regulations that are harmful to workers, and the boss does nothing to protect the workers from it. So, I don't want to be one of those people that says like, oh, when there's bad policy, then workers will just organize. But I do think that it can make workers realize that the protection that they have comes in a union. It's not going to come from the government. It's not going to come from a boss.
Fred, anything you want to add?
I'm going to stay mum on this one.
Okay.
Thanks.
I think we probably have time for one last question. So I'm going through all of the questions that we have from the Q&A. I guess I'm going to take two questions and put them together and see if it fits together. It has to do with gray area and maybe not so gray area. So we got a question about how is this going to affect the board's rulings with respect to joint employer, for example, which has not been specifically defined in the Act. And so that becomes a question of what's going to happen to those kinds of questions which are not defined in the Act. And similarly, Weingarten and the Weingarten rule, which of course is board-made rule. So how is this going to impact, if at all?
Mm-hmm. And I think the answer is time will tell, and I hate being super vague about it, but we have to see what arguments people can raise, or people do raise. I think it's, as we've been saying, it's sort of like we lawyers, when somebody comes to us and says, can they sue us? Can somebody sue us for doing this? And we lawyers say, like, anybody can sue anybody. And it doesn't mean they're right or wrong, or there aren't arguments in favor of it, as Craig has said, or to defend it. And I think, we will just have to see what arguments people make. But it is, as we have seen in the last 3 weeks at the board, people are raising Loper-Bright repeatedly. And I would expect that we will see that case cited in litigation involving whether it's a joint employer or Weingarten or whatever important acts the board, whatever sort of major policy decisions the board is making.
Thank you. Well, we're actually out of time. We've reached 2:30. I do want to read a comment that we got from someone, because I think it's just important. This person writes to us and says that we're doing a disservice to civil servants by using the term deep state. And so the concern is that by using that language, we're in some way disparaging the people who work so hard in all of these agencies. And so I just wanted to let everybody know what one of the people who participated today had to say, because I think we would never want to disparage the civil servants who work in federal and state agencies. It's not a term that actually this group coined. It's a group that has been coined by others who are concerned about apolitical civil servants who work in state and federal agencies. But I just, for purposes of clarity, I just wanted to use my position as moderator to answer what was listed and to sort of give it a framing. I want to thank Charlene and Fred and Craig for an incredible discussion. I think there's going to be a lot more for us to talk about and for people to talk about Title VII, the ADA, the equal pay. There's so many statutes that this is going to involve that I think we all need to be vigilant and be aware that there's a change. How big a change, Craig, as you keep pointing out to us, we're not quite sure yet, but it's going to play out in the courts and in the agencies, and we're going to have to deal with it. I want to thank everyone who joined us today, who participated, and who stuck with us, notwithstanding some of the technicalities that happened to us. It's not your fault, Fred. It's part of the Zoom world that we all live in. And I want to thank Megan and Anne, who are the two people I worked with at Caro to get this up and moving. And again, thank you all very, very much for joining us. We look forward to having you join us on other programs that we do. So thank you all very much. My name is, if you haven't figured this out yet, my name is Esther Bigler and I direct the Labor and Employment Law Program. And everyone, thank you so much for joining us. Bye.